Federal Rule of Evidence 405, methods of proving character. We have 405A and 405B. We're going to discuss each of them separately. So we'll discuss 405A first. 405A focuses on testimony about someone's character by reputation or opinion. So basically, when character evidence, character evidence, is finally admitted through 404A and 404B, like we discussed in our previous video, it may be proved by testimony about the person's reputation or opinion. Example. So I'm trying to demonstrate that my client, the defendant in this matter, is a peaceful man. I can call, let's say, one of his coworkers to the stand. And once the character evidence of my client's peacefulness characteristic is in fact admitted, I may prove it by the testimony of his coworker about his reputation at his workplace or the opinion of him by that individual. So if his reputation among the community of his workplace is that he's a nice person and he's a peaceful man, then that reputation testimony will be admitted. Or I could simply ask that witness, hey, witness, what is your opinion of my client, Mr. Anderson? That is an example of me trying to get testimony from that witness to basically show that he is, in fact, a peaceful man. And if that testimony, the opinion testimony, states from that witness's mouth that, hey, Mr. Anderson in this matter is in fact a very kind man. I've never seen him angry. That is an example of me trying to prove my client's characteristic of being a peaceful man, because not only am I showing the reputation of him being a peaceful man in the workplace and being a kind person in general, the opinion of the individual on the stand is stating that, hey, my opinion of Mr. Anderson is that he is a kind and peaceful man who would never hurt a fly. That's an opinion. Furthermore, on cross-examination, the prosecutor will be able to inquiry into specific instances of conduct, and that will allow the prosecution to try to poke holes into the witness's testimony. So, for example, if my witness states that Mr. Anderson is a peaceful man among the community at his job, then that'll be an example of the prosecution going up next on cross-examination and being able to inquiry in good faith into certain instances of the defendant's conduct. So an example of that could be a situation where the prosecution has evidence of the defendant getting written up for yelling at someone, for showing a propensity for violence. So on cross-examination, the prosecutor can technically inquiry to that witness on that instance of conduct to ask that witness, hey, did you know that the defendant, Mr. Anderson, was written up for yelling at a coworker? That's an appropriate question because the prosecutor is inquiring into a specific instance of conduct to try to rebut the reputation or opinion testimony of the defendant being a peaceful man. Therefore, this is A-OK. But if the individual, the witness in this matter, says, no, I didn't know, then the prosecution must stop there. Basically, you can't go on the deep end. But in the end, a simple inquiry is permitted by the prosecution in my example. Furthermore, for 405B, by particular instance of conduct, when a person's character is an essential element of a charge, claim, or defense, the character may be proved by relevant instances of his conduct. So to dumb this down into plain English, basically, let's say that we have a negligent entrustment case. So we have a civil matter where the plaintiff is suing the defendant, and the defendant entrusted his car negligently to his stepfather, who has a revoked license and a history of getting into car accidents, which led to the revocation of his license. Under that situation, the attorneys may, in fact, ask questions about the person's character because it is an essential element of the crime, of the civil matter, because of the fact that, again, we're talking about negligent entrustment. So that is an element of that claim of that civil suit, because the defendant in this matter entrusted his car to a person he shouldn't have. So asking questions about, did you give the keys to your stepfather who has a revoked license and who got into a bunch of car crashes, would be a-okay to ask. Furthermore, when it boils down to defamation, that's another civil matter that could be applicable to this situation, is that the character of the person is at issue in this case, right? Because as we know, for defamation, you got to prove that the statement was defamatory, the person stated it, yada, yada, yada. So to prove that element, that the statement was defamatory, or even to prove that the defense of the matter is that, hey, I told the truth, therefore the statement was not defamatory, therefore jury found me not guilty, the lawyer can in fact inquiry, basically not inquiry, but ask questions for relevant specific instances of his conduct about the situation at issue. Okay, whether or not it was the truth, whether or not the statement was in fact incorrect, like calling him a thief, but he was not a thief. Those are examples of being able to be permitted to ask questions as long as it's an element of the actual charge itself, the claim, or the defense of the character, of the situation that's going on, I meant to say. Therefore, that is 405 for methods of proving character.